I welcome you all to this edition of Illuminate by Meritto. For those who don't know, Meritto is the operating system for student recruitment and enrollments worldwide. Trusted by over 1,000 plus education organizations, from edtech companies to higher education organizations, Meritto streamlines processes for sales, marketing, admission, finance, and operations team. Meritto empowers 1 billion student engagements annually, processing 100 million inquiries and managing 5 million applications on average. And for those of you who are onto their first Illuminate by Meritto webinar, it is a series of live webinars where we bring you the latest insights, best practices, and technology on everything about student recruitment and enrollment. We host expert speakers from Meritto alongside experts, thought leaders, and decision makers from the world of education, offering unparalleled insights for the education industry. And today we have Dr. Anand Padmanabhan. Dr. Anand is the Dean of Vinayaka Missions Law School and a leading expert in technology law and policy. A graduate of the National Law School of India University, he practiced law in Chennai under senior advocate Sri Arvind P. Dattar before transitioning to academia. He holds a master's and doctorate from Penn Carey Law School and a master's in management science from Stanford University. Previously, Dr. Anand was the founding dean of Sai University's Law School and led technology and policy research at the Carnegie Endowment for International Peace. His expertise span intellectual property and emerging technology laws. We welcome you, Dr. Anand.
Thank you very much for having me here.
And we also have with us Surya Singh. Surya Singh is the Vice President of Data Security and Compliance at Meritto and is an expert in the cybersecurity with ISC2 certification. He has been instrumental in guiding Meritto through its ISO 27101 and SOC 2 Type 2 compliance journeys and is actively steering efforts towards GDPR and DPDP adherence. Surya holds a master's degree from the prestigious Indian Institute of Management, Calcutta, reflecting his deep knowledge and leadership in managing data security at an organizational level. We welcome you, Surya.
Thank you so much, Tanya. And hello and good afternoon, everyone. And extending a warm welcome to our experts as well as our participants. So before
So, due to
starting on, yes, Tanya.
Surya, I was just want to mention it for our audiences that due to some health reasons, Puneet will not be able to join us today. Now, I would like to hand it over to you, Surya, to take us further. Thank
No
you.
worries. We definitely want her to take care of herself and we will just proceed with the session. Thank you, Tanya. So now, before we start with the session, let me just set a few expectations for our participants with respect to this session, what they can expect. So what we will be discussing is our experts will be telling us what DPDP is, who all it applies to, what are the obligations of the educational organizations when it comes to fulfillment of DPDP or compliance with DPDP. We will be understanding what are the rights that have been given by DPDP to the data principals, what are even the duties of data principals, what are measures as an organization, as an educational organization, we have to ensure or we have to build in order to ensure that we are DPDP compliant. And last but not the least, what could be the aftermaths if we are not compliant. Now, for all of our participants, I would request that if you have any questions at any point in time, I request you to please post the questions in the chat box. We will take up a few of the questions towards the end as per the time permissions. Now, so let me start the session and I have my first question for Dr. Anand. Can you explain us what Digital Personal Data Protection Act is in detail and why exactly is it so crucial for educational organizations in India today?
Absolutely. Thank you so much, Team Meritto, for having me here. And Thank you, Surya, for setting the context. So I would like to, in fact, go a step before DPDP because I think DPDP in a way a culmination of a lot of debates that we have been having in the country, starting with the right to privacy debates. As we know, when Aadhaar became a reality. Equally challenging was the fact that it is making use of our biometric data, and that biometric data is residing in servers, and that it is all being processed every second, depending on where you are trying to access, your Aadhaar data and to avail what services. So this all finally resulted in a situation where there were very many concerns as to whether the private data of individuals is truly residing in a safe manner, and whether it will be processed in a legal manner. Now, as the constitutional challenges to Aadhaar mounted, matters ended up before the Supreme Court, and there was a very interesting argument taken at one point in time, which was that some of the arguments are not maintainable at all under Article 32 of our Indian Constitution, which allows citizens to directly approach the Supreme Court for violation of fundamental rights. And what was the genesis of that argument? A very creative plea that the right to privacy is not a fundamental right. There were some cases, indeed, of the Indian Supreme Court in the past that had kind of indicated that the right to privacy is not a fundamental right, because back then, before the Indian Supreme Court's verdict in Maneka Gandhi's case in 1978, the Indian courts were taking a very narrow view of various rights in our constitution, including Article 14, the right to equality, and Article 21, most importantly, the right to life and personal liberty. But very importantly, in 2017, uh, a unanimous verdict of the Indian Supreme Court came about in Justice Puttaswamy case, which made it absolutely clear, that the right to privacy is a fundamental right. So I think that's something that I want to highlight, because in that very same ruling of the Indian Supreme Court in Justice Puttaswamy's case, the court made an important and interesting distinction between what would fall within the realm of privacy action, where you have a petition or mainly a writ petition that is maintainable against the state for abuse of privacy by the state, like cases like telephone tapping, for instance, right? Or cases like getting into your internet search records by the state, versus, on the other hand, the digital footprints of an individual, which are processed to result in profiling of individuals by private organizations. Of course, that does not mean that the data protection laws will not apply to the state as well. But the larger point is that these are two very different types of action. One is the exercise of state authority in order to do something that may be violative of an individual's privacy. And the other is an exercise of private power, or largely in the context of private enterprise, really, whether by the state or by the other private entities, right, in order to uh, understand what an individual is doing, gather all that digital data, create profiles of individuals, and then target them as, in most cases, as consumers. But the challenge, as far as data protection is concerned, is that when this happens, usually it is exactly like what happens in the context of the Food Safety and Standards Authority of India. I always like to draw this parallel, because what happens in the kitchens of vendors who are preparing food, or manufacturing processed foods, is exactly like what happens inside organizations that are processing your data, in the sense that it is a black box. You really do not know. So you need technical competence, something that we can, talk about a little later in this conversation. You need technical competence to really understand whether the standards, the rules, the regulations set by the law are being complied with or not. So evaluating compliance itself becomes a challenge. But keeping that aside, the idea of a data protection law, therefore, is simply that there is a lot of digital personal data being generated. But are people aware? Firstly, are people willingly offering such data. So that's the point of collection of data. The second is, are people aware that the data is being processed in a manner that was promised to them at the time of collection of the data? The third is it all maintained in a safe, secure, and accurate manner? And the fourth, of course, which is the point that you made, Surya, in the beginning, what happens if one of these things, or all of these things, or some of these things are not being complied with? What is the right of the citizen? So these are the key points as far as a data protection law is concerned, any data protection law. The content may vary. Some may be more stringent, some less so. And we can always talk more about that in the course of this conversation. Now, as far as educational institutions are concerned, I would like to again split this into two different types of institutions. One, primary and secondary education, and then higher education. Why do I make this distinction? Because of a very vital point in the data protection law, which is the age restrictions. So the moment someone is a child below the age of 18 as defined by the Act, there are additional restrictions that come in automatically to the collection of data and the processing of data. The moment you go to higher education, where again, I'm only assuming here that everybody in higher education is above 18, may not be the case. There may be boy or girl geniuses, who enter higher educational institutions at the age of 14 or 15. And that is, I mean it in a very serious way, because in such cases, obviously, the institution should have to create systems. A higher education institution must necessarily create systems to look at their data separately. That is important. But more on a more general basis, if I may say, for higher educational institutions, there are two different aspects. One is the aspect of the DPDP in general. What are the compliances for adult data? So that is one aspect. The second is higher educational institutions, unlike primary and secondary institutions, today increasingly in India do a lot of research. And research requires what? Data. Right? So how are you going to be able to use data? So we can also speak more about the research exceptions, or at least the sort of initial push towards having an exception in India. We'll have to see how that pans out as we go along. So enquiry is a very important aspect, done much more in higher educational institutions than in schools, though I'm not saying schools don't do any research, but the kind of data driven empirical research is much more in the context of HEIs. So what are the kinds of rules that apply when they are carrying out research is another important issue. So these are the various ways I can think of at the moment. Of course, Surya, I mean, please feel free. This is an interaction really more than a lecture from my end on the Data Protection Act. So wherever you feel, there are things I may have missed out, please, feel free to weigh in on this.
Definitely, Dr. Anand. So, as you rightly pointed out, first of all, regarding the evolution of the DPDP Act, or rather the data privacy norms. So, I completely agree with you. I mean, it is not just that this year, the last year only was the first time that we came out with the Data Privacy Act or framework, but actually, the journey started back in 2000 when there was an IT Act, Information Technology Act. Then you even mentioned about the Puttaswamy case judgment, right? And then the draft personal data protection bill. But finally, in the year 2023 was when the DPDP Act was passed. Now, while you have mentioned all these things, Dr. Anand, help me understand what are the core obligations of educational organizations to ensure that they are DPDPA ready or DPDP compliant?
Perfect. I mean, that's of course a very detailed inquiry that may be needed. And I cannot also, I mean, the main disclaimer from my end, that I would like to offer here is that a lot of what the compliance framework will in reality look like, we will only get to know once the rules are framed. So the DPDP Act at the moment is sort of at a 30,000 feet level, saying that these are the broad obligations. But once you say that these are the broad obligations, there still is the big question of how do you execute the broad obligations? Now, that is an area where I cannot weigh in with great degree of authority, because the information that we have at the moment as citizens of India is still very limited. The rules have not yet come into effect as far as I know. I do not see any version that has been up for public consultation either. And maybe, I am wrong on this, so please correct me if I am. But this is to my understanding where things are at the moment. It was actually taken up as a priority item immediately after the present the government came to power, and it was informed or conveyed that within a month they would be up for public consultation. But so far, I have not seen much movement on that front. But that being said, I would say that before we get into all the complexities and how things will look like and so on, let us just take, and thank you for bringing that up. Very good. Let us just take out whatever is there on the screen right now. I hope all of you can see this screen. This is very, very well organized, and it will help me structure my thoughts. So thank you, Surya, for that. So
Thanks,
the
Dr. Mani.
first and the most critical element is consent management. Because at the heart of the DPDP Act, finally, what we are saying is that you need to take consent in a particular manner, and that consent has to be of a particular kind. So the first obligation is a notice, either prior to or while you are taking consent. Now, what should that notice really say? That notice, or provide notice about, right? So I'm just going to rely on the act because I do not want to give incorrect information on such matters. The most important element, like I said, is the consent framework. So there, if you look at the provision, the notice has to indicate to the data principal. So who is the data principal? Let us say you are a college. The data principal is the student, because you are taking the student's data, right? You are a school. The data principal is again the child. So you have a data principal. And then you have the data fiduciary. Who is the data fiduciary here? It is the college, because they are the ones who decide what to do with the data. And then there is a third person, the middle layer, which is the data processor, right? So that's just the architecture. Anyway, coming back, the notice should inform the data principal, and it must be given by the data fiduciary. It must inform the data principal the personal data and the purpose for which it is proposed to be processed. So suppose you are using financial data, you are gathering financial data for refund of tuition because somebody gets a scholarship. That has to be made very clear that I am taking your from personal financial data for this reason. The manner in which the individual can exercise her rights under certain provisions, which I'll come to very soon. And very, very importantly, the manner in which the data principal can complain to the data protection board. Right? So these are the three main ones. So you inform somebody what is being collected, you inform them how to exercise certain important rights, and you inform them how to prefer a complaint in case there is a grievance. Now, what is very, very important here, Surya, and I want to stress this, is the next provision. In cases where the data principal has already given the consent before this DPDP Act came into force, right? Even where in such cases, the data fiduciary has to, within a reasonably practicable period, provide the same notice with all this information, which I just mentioned, to the data principal. So I hope this part is clear. So this notice is a very vital aspect to kickstart the process of gathering consent. The next important aspect, and I'm going to largely speak about consent here because to me, before we get into all the other details, this consent part, all organizations should know. The rest of it, you can always get guidance from, your lawyers and so on. But this part, all organizations should internalize it because this is at the heart of DPDP Act, right? So then you move to the next provision, which is Section 6 of the Act. Now, there are some qualifiers for how this consent should be taken. So such consent should be free, obviously, cannot have a gun on the head. Specific. This is very important. You need to take that individual specific consent to a particular type of use, of the data. It must be informed. You cannot muddle their mind, with multiple, ideas and say, oh, I'm taking your consent for this, but it may be used there, it may be used that. Unconditional and unambiguous with a clear affirmative action. So the consent, the data principle must unambiguously, provide consent. It cannot be that the person says, look, I can only give for this, and then you decide, oh no, but that's fine. We had asked for something much more, so we'll continue to use it for something much more, right? So these are very, very important things to bear in mind. One thing that I also like about the DPDP Act is that it goes back to some of the older traditions of lawmaking in the country where illustrations are given. If you take the Indian Contract Act, illustrations are there, and these illustrations are very helpful in understanding the meaning of these provisions. So I urge our participants here to go through the illustrations. They're very, very clear and they're very helpful in understanding the content of the law. Now, thereafter, we go into something very, very critical. This is a matter that was debated during the, debates surrounding this DPDP Act, right from the Sri Krishna Committee period. Every request for consent has to be in a clear and plain language. Now, we all know how sometimes, we enter our data, right? There is an app and it gives you this very long box, with so many conditions, you don't understand what they're trying to say. So it has to be in a very clear, plain language, including language specified in the 8th schedule to the Constitution. An option should be provided. These are all important because, see, today we are talking about inclusivity in higher education. But inclusivity means that, and it's not just something that higher educational institutions or schools can just use as a check mark. Inclusivity means you have to create the processes. And one important process for inclusivity is that you need to have your consent form prepared in languages other than English. Otherwise, tomorrow, the learner could very well say, I am a person who came in because of your inclusivity mandate, but I did not understand, what you were trying to say. So these are all important, tricky issues. And of course, important to be kept in mind. Now, finally, of course, the data principle can also withdraw the consent at any point in time. Of course, this will not affect matters on which consent was taken and which were already used for data processing. But for future matters, you have to immediately put a stop to your actions. Then, of course, there is something called purpose limitation. Why is this important?
Sorry, Dr. Anand, we are not able to hear you. Can you just check the mic once?
Hello? Hello, am I audible? Can everybody hear me?
Yes, Dr. Anand, now I can hear you.
Oh, okay. Is there some issue with my connection or is it okay?
I guess it was just an issue, an intermittent issue. Maybe we can
Okay,
just.
sure. So I think we have covered the consent framework. Now I'm getting into purpose limitation. I'll make this very quick because these are all important topics. So I don't want to, just skirt it in a haphazard way. So let me come to the idea. Again, we see that there are apps that collect so much of data, right, and say we will use your data for all kinds of purposes. That should not be the case. if it is a health app, and in the specific context of an educational institution, let's just take our own context here. A school needs data for certain purposes. It cannot say, I'm going to use your data for starting an insurance company, or I'm going to use your data for starting a mobility company. That cannot be the case. And today, because there's so much talk about data being the new oil, there is a lot of incentive to either use it directly or use it indirectly by selling the data to data processors who will then use it for all these purposes. So purpose limitation is absolutely essential. So is data minimization. What does that mean? That means that if I need your financial data, I only need your financial data. I don't need your photograph, maybe. I don't need your location. I don't need your video. I don't need your voice. And these are all important aspects, but not all are important for the purpose for which you are using the data. So that correlation between or connection between the data gathered and the purpose served, and limiting that purpose to what is absolutely consented for, is very, very important. And that is how the chain is closed. Then comes data security. What are the standards by which you are storing the data, right? Or by which you are processing the data? I mean, we have heard so many vulnerabilities recently, and particularly with child data. TikTok, for instance, had a huge episode of leakage of child data. Before that, VTech, another organization, Hong Kong based, about 4.8 million, child data points were, leaked, right? So data security becomes critical to ensure that these leaks do not happen. Then, of course, you have data retention, right? I mean, you to retain, the data for a certain point of time only, not beyond that point. You retain it for the period for which you need to satisfy the purpose. Now, of course, there may be some law that says you have to retain it for 90 days. Recently, the Bar Council of India, for instance, came out with a circular, which is applicable to all law schools, where it says the video recording of the CCTV. There must be CCTV recording inside, camera placed inside the classroom, and that recording must be kept retained for 1 year. Now, of course, one could contest the privacy implications of something like this, but the point I'm making is slightly different, that if the statutory authority says you have to do it, then that's a different matter. But otherwise, you don't retain for 1 year, right? You may not even, have CCTV cameras, unless there is a regulatory requirement of this kind, inside a classroom or inside some private spaces, etc. Then, of course, you have the issue of data subject rights that you have rightly pointed out, respecting the data subject rights. See, now I am consenting to you using my data for a certain purpose. First thing I need to know is, what are you actually using it for? Like I said, it's like the kitchen story. You don't know, right, unless you go inside the kitchen, what ingredients are being used. Similarly, as a data principal, I should be given the opportunity to find out how exactly you are using my data. For what purpose are you really using it? The actuality of the matter. Then there is, of course, the question of data accuracy. Are you maintaining incorrect data about me? If you are, then you need to correct. Now, of course, there is also the concept of data erasure, right? I mean, there is a fear that, this data or these data points can cause harm to my reputation. So can I not ask for erasure? I am, of course, not getting into the nitty gritties of each of these rights, but the point is that educational institutions have to create a system in order to comply with these new types of rights and new types of obligations placed on them on account of these new rights given to data principles. Now, I want to slowly move away a little bit before I come to data breach notification to address the issues specific to schools. As far as schools are concerned, consent has to be from the guardian. Consent has to be from the guardian, because the assumption here is that it's a child who we are dealing with. But it doesn't stop there. Today, as the DPDP Act has insisted, there has to be a mechanism for verifying the age of the child. Now, as we go more and more towards digital learning solutions, this becomes absolutely important. What is the user ID or proof that will verify the child's age? Today, there is no clarity yet on that matter, but it is an important matter nonetheless. Right. So the point I'm trying to make is that as far as schools are concerned, there are these two additional safeguards that have been brought in. One, consent by the guardian, and the second, where children are directly accessing a mechanism to verify their age, which increasingly becomes important in the context of digital learning. And we'll have to see how that mechanism is implemented through the rules, because this is a very important matter which is up for discussion at the level of the rules right now. So that is where things are as far as schools are concerned. Now we come to data breach notification. What happens, if all of this, any of this, is observed in the breach rather than complied with? Then, if there is a leakage of data, immediately that information has to be provided to the data principal, right? If they are not provided with such information, that then creates a problem of what we call information asymmetry. So that information asymmetry has often been used by organizations to the disadvantage of the individual. When Cambridge Analytica happened, we all got to know about it from the newspapers, essentially, that our personal data, I mean, maybe not mine, maybe not yours, but that of several people, was shared with a political consulting agency, right? And there was some, improper use. Of course, that is not a data breach, it is more a improper use of data. But similarly, when there are banking hacks and when there are many such situations, the first response of organizations is to hide, not disclose. But really, it has to be the other way, that there has to be maximum transparency. Of course, you don't need to create panic. There has to be maximum transparency on the part of the data fiduciary in providing detailed information, if not directly to the data principal, to the data protection board, sir, so that they can take necessary action to ensure that data breaches are addressed and customers are made aware that their personal data is currently, as we speak, at the risk of being appropriated for some other purpose. Data processors and third-party vendors, again a very important one. What sort of agreements are you entering into with third parties? See, because in contract, in say traditional contract law, we have something called privity of contract. If you and I enter into a contract, it does not bind the third party, right? But that then results in situations where companies use the route of a third party entity to get over their contractual obligations. But the DPDP Act is very clear that cannot be, because data processors, third party vendors, everybody is bound by these similar obligations as the data fiduciary, the person who is gathering the data through the data processor, processing it, but finally has the ultimate control or say over how the personal data will be used. Finally, of course, we have accountability and governance. Now, this part depends again on one category called significant data fiduciary. If you become a significant data fiduciary, then you need to have a data protection officer. You need to carry out very regular data protection audits, data protection impact assessment. So there is a set of governance norms surrounding that, which we can go into if there is some further questions around that. But otherwise, the most important, really, to sum up all of this, the most important from where I look at organizations is get your consent gathering framework absolutely correct. Ensure that there is no tarnishing of the way in which you are capturing data. It fully follows whatever procedures I mentioned. Section 5, notice. Section 6, consent. And including the language, simple and plain language, and clear and plain language, and so on. So that is, to me, at the moment, before we look at the rules, etc., the one thing you can certainly do, you don't need really any of the rules or anything to kick in. One thing you can do from today is to strengthen your consent framework and understand its limitations as well, including the purpose limitation, the data minimization, and so on. On other matters, including data security, retention, breach notifications, and of course, in the context of children, the way to, verify age, etc. Let us wait for the rules. But this itself is a lot of work for organizations. So let's get started.
100% Dr. Anant, what you mentioned is true. There are so many obligations for the data fiduciary, and we should get started with some of these things which are really mandatory as of now, while the rules can kick in anytime, which we are expecting somewhere close to month end and so on, right? No, Dr.
Yes.
Anant, while we understand that there are so many obligations and so many things to be done to in order to ensure that one is compliant with DPDP, what practical implementation challenges do you foresee for the educational organizations to be compliant with all these things? While you mentioned about the primary education, wherein age verification, wherein the guardianship verification, there are certain process mechanisms that will come up with the rules. But what sort of other practical implementation challenges do you see for educational organizations in order to ensure that they are DPDP compliant and they are able to fulfill all these obligations that have come out somewhere through the act?
I think, Surya, the main practical challenge will always be training. You have to train your staff even before you
Mhm.
get into hiring additional staff, etc. Let's be realistic. The educational institutions are not giant corporations. Maybe some of them are, but most of us are organizations that come with a social purpose and mission. We operate largely on a break even model because that is the philanthropic commitment that many educational institutions come with. And even in cases where you are not really in a break even model, is largely donor driven. So there are of course various higher educational institution models, but I don't want to get into that. The point I'm making is that you cannot have a team like a Facebook or a Google, to comply with the DPDP Act, right? So the most important challenge I see is the training challenge. How are you going to train your people? Because, like you have pointed out here, resource allocation, budget limitations, insufficient technological resources, then you have to get into the awareness point because your staff, your existing staff, may be your initial data protection team as well. I mean, there is no way, you can ignore that reality in the context of such organizations. So, if that is the case, we need to then train them. There is a lot of training required to make them understand the law. Then, of course, in the context of age verification and so on, there is going to be a technological investment, because it may not be the case that you can easily use some user ID and be done with it, right? There could be some age gating required, perhaps, you know and similarly, on the technical side, you may need to really uh, in my my understanding, to my understanding, you may really need to start onboarding vendors at a higher cost, because vendors themselves, they are so-called data processors, right? They are also going to have some cost implications on account of the DPDP Act. See, one thing that has been a criticism against the act, and this is going outside the scope of education to a more general criticism, is that when you did not have this act, of course, you had the IT Act, but then the IT Act was very weak on the penalties and so on. Before an act of this magnitude with this sort of penalties and so on, there is a sense that data can be monetized and you make your money from the monetization of data. Now there is a sense that, sure, we need to try and monetize, but we may not be able to monetize it in the way that we could before the act came into effect. So once there is that sense of some limitations on monetizing personal data, then the only other way is to increase the cost of the service that you're providing. So this could be a challenge, across the board, not only educational institutions. So that's something that then of course we'll have to see from the penalty standpoint, is it going to be a very high on liability penalty type regime? In which case, again, organizations that are running on break even, they could end up going broke, because the penalties can be fairly high under this act. I mean, I can't recollect the exact percentage, etc., but I think 5% and so on. There are some parameters mentioned which we can look into. So I think that is another concern.
Okay, fair enough. So, Dr. Anand, while we have covered the obligations of educational organizations and what practical implementation challenges that they might face, let's look at the other side, which is data principles. So, could you help us understand what are the rights that have been provided to data principals by DPDP, as well as there are certain duties that data principals have to, right? So, could you please explain us what are the rights and duties of the data principals?
Absolutely, absolutely. So there are, like I mentioned a little while back as well, right? You can basically ask for any data fiduciary to provide you, to provide you the data about you that they hold. What is the information about you that they hold? See, they are processing your information. What is your risk profile? You can ask them, because that is the outcome of your personal data, right? So that black box situation will hopefully come down. Somebody is using, I mean, a lending app, let us say, is using my data to put me in a certain box, right? Of either I'm entitled to a loan or not, or only entitled to this much, etc. That decision making by accessing information about my personal data, I am interpreting it broadly. There are people who may interpret it narrowly too. But I think it is a remedial law. So, under the principle of statutory interpretation in law, remedial laws have to be interpreted liberally. We are remedying the situation of, indiscriminate use of personal data. So, I'm saying that you have a clear right to understand your profile. You may not be able to ask them what is your decision making parameter, but you can reverse engineer the decision making by asking what information about my personal data have you gleaned, by processing it. The second, of course, we mentioned already, inaccurate data residing, can get it corrected. The third is grievance redressal. That was a big vacuum in the IT Act. In fact, Surya, most of the things that I mentioned by way of consent, data minimization, purpose limitation, this was all there in the IT rules, the SPDI rules, created under the IT Act. But what is certainly not there is an effective grievance redressal mechanism. So now that mechanism has been created, and of course the right to nominate, and so on. So I think, these are the main, rights and duties as far as I can see.
Okay, so now while we know that there are multiple data privacy frameworks across the globe, be it European Union's General Data Protection Regulation, GDPR, or CPRA, and so on. So help us understand how DPDP is different from those data privacy frameworks, especially GDPR.
Right. Of course, this is a never ending, debate in our privacy circles that, we started off with something very ambitious from a regulatory standpoint to have something like GDPR, and we ended up with a very meek, law. But of course, I think each country has its own challenges, and we should be evaluating these things only after the rules come into force, in my view. But having said that, like you rightly pointed out here, there are some key points. I think the most important one, as far as I can see, and it's a very critical one. I mean, that's not. I can't see it actually here, but this is a very important one. The GDPR prioritizes sensitive personal data. we too, in the earlier drafts of this law, considered data into two different categories, sensitive personal data and personal data.
Right.
But today, the version of the Act as it stands does not make that distinction. In my view, that is a glaring omission. I don't know whether that's the right expression to use, because I don't think it is an omission. They knew and they consciously. So I would say it is a very conscious deviation, and one that I feel has led to the watering down of the law, because many of the granular, you know, differences that you could have brought about lay in this one very fact, that some types of data are sensitive personal data and some are personal data. So if it is sensitive, involving health data, financial data, etc., in such very critical cases, the level of regulatory intervention has to be higher. If it is not so sensitive, then the level of intervention can be lower. So that is one very important aspect that I would like to flag right off in the beginning. The second is, and this is again an issue where there has been a lot of concerns, that we have not really, I mean, in the earlier versions, we spoke much more about data portability. In the current version, there is much less focus on that. Then again, data transfers is an area where there has been a lot of, contention there. And India has taken the approach of, more than relying on safe transfers, to rely on localizing, certain types of data within our borders. So that is happening in the case of banking data and some of the other types of data. And then, of course, data protection principles, on that front, again, I think mostly we are following the same OECD principles, so that is fine. And of course, there is also the deeper critique. I don't know how relevant it may be here. Maybe it is, which is the power of the state by way of exceptions under the data protection law. The exceptions are far less in the context of GDPR. The exceptions are far more in the context of the Data Protection Act, and therefore there is a fear that the state will be able to do what private companies cannot do, but can make unlawful use, or not unlawful, unconstitutional use of your personal data. So there is that fear, because there are not too many safeguards when it comes to things like law and enforcement, national security, etc. Some of it may.
Sorry, Dr. Anand, we are not able to hear you.
Hi, Surya, can you hear me?
Yes, sir. Now I can hear you
I
definitely.
think were you able to catch everything I said, or was there a?
Yes, it was just a pause or towards the last 30 seconds, I would say.
Okay. Sorry about this. I don't
No
know
worries,
how.
sir.
So that's it from my end. So these are the main, sort of issues there. Yeah.
So while we have discussed about the differences with respect to other data privacy frameworks, now I would like to come to how should educational organizations prepare for the worst case? Worst, when I say it could be a potential data breach that might have happened. So how should organizations prepare themselves to deal with such situations?
Excellent question, because I think there is a sense of fear when it is, when it comes to these matters. There's a sense that, oh, if you commit a breach, it's fine immediately. That's not true. Like what you have highlighted here, correctly. You have to first, be transparent. You have to notify. That lack of transparency is what, in fact, in most cases, I feel affects organizations more than facing a breach. Because let us be realistic in the world that we are today. The breaches are not uncommon, are not uncommon. So you have to kind of work with that reality, but you need to quickly respond. So for that you need a team. So that I think is the structure that you need to create internally, which I think you have presented. So like you have a proper IT team. Like I said, in the early days, it may simply be that you have to train some of your existing staff, to kind of help you when these matters happen. And as you grow in size and scale, you certainly need to have a more structured team and a hierarchy of flow of information so that these matters are addressed in a proper manner.
Great. So with this, Dr. Anand, I would like to ask you one key advice that you would like to offer to all the educational organizations to ensure that they are DPDP compliant while maintaining all the operational effectiveness and other things. Dr. Anand, can you hear me?
Yeah, now I can.
Yes. So I was asking one key advice that you would like to provide to all the educational organizations so that they are compliant with DPDP while maintaining their own operational effectiveness.
Right, right. So, I mean, the one key advice is, focus at the moment all your energies on getting the consent framework right. Because that is not going anywhere. That's the most critical piece. The rest of it, let's figure it out as we go, And that's really my advice, Get the consent framework right.
Mhm. Okay, fair enough. So thanks for that concluding remark, Dr. Anand. Let's just quickly take up a few questions that are in the Q&A screen.
Yes, I saw that. Does it
Yes.
mean that a
So
company can also exercise data principal rights? Tapan has asked. Tapan, I don't know the answer because, we'll have to, I mean, of course, this is a matter of statutory interpretation. Can it or can it not? Uh, the idea behind the personal data protection law is that it is personal data. Is company data, personal in the sense of what is typically covered under personal data protection law? Or should there be a different framework like trade secret law or other types of laws? Is something that we need to kind of go a little deeper into. I don't have a very clear answer. Now, regarding consent fatigue, yes, I agree. Consent fatigue is an issue, but that is where the Act is now saying that it has to be clear and plain language. So I think hopefully that should address, but we'll have to see the regulatory authority and how that is able to assess these, consent gathering frameworks, and maybe one or two judgments may be required, to say that, look, organization Z, what you have designed is not simple, it is not clear, it's not plain. Maybe, then other questions. Excellent question. Excellent question. This is one of the most important. You cannot use that data. You cannot use that data for other kinds of business purposes. A lot of organizations do it. They sell the data here. It is a very bad practice. So you need to have a CRM like Meritto, for instance, which follows principles of data, storage, and which follows principles of data minimization, has a proper streamlined way of access rights, etc. You need to go with entities like that, and that is how you store the data. And then, of course, Meritto, I know that it has a practice of data erasure. You erase the data, right, after a certain period. So these practices are required. So organizations that are not doing these practices, you are going to be in trouble. You cannot go with the, it's not like before, you have to be very careful about this.
definitely, Dr. Anand. So just adding on to that particular aspect. So Dr. Anand, it is kind of a shared responsibility. So while Meritto provides certain security features, say for example, there is multi-factor authentication, there's single sign-on, there is a strong password policy to ensure that There is no unauthorized access as such, but yes, when I say shared responsibility, it is up to the educational organization to ensure that they implement these security measures in their panel, thereby ensuring that there is no unauthorized access. At the same time, I would like to highlight a few facts regarding the data masking. That, for example, you can define what fields are there which contains a personal or sensitive data, and you can mask that data so that nobody is able to access it until and unless they are authorized to access and make use of it for some processing, right?
Absolutely. Absolutely.
Right. So with this, let's move on to the next one. We get a lot of data from publishers and offline events. Will it be safe to store this data and send them mailers, SMS, or calls?
Did they consent? If they did, that's fine. If they haven't, that's the
Okay, so
simple
it is
answer.
completely based on the consent you are saying,
Consent
Dr. Anand.
framework. Yeah, exactly. What have they consented?
Right. If there's some educational legal organization that only offers courses and deals with a lot of PII of students, how they can implement consent framework if they do not make the student digitally consent to the terms and privacy policy that is DPDP compliant?
Yeah, I mean, there is no restriction at all on digital consent. The consent framework can be entirely digital. The point is simply that it has to be in clear and plain language. It's about the design. It's not about the medium. We can still have those check boxes, but maybe they'll ask you, depending on the kind of, that's what I said, the rules may provide a little more clarity. There may be some sectors where they say you have to provide video information. Who knows? See, the country is changing, the model is changing, many things are changing.
Right.
That's what I would.
So thanks, Dr. Anand. Considering the paucity of time, we will be able to take up only these questions. For remaining questions, team NoPaperForms will connect with the respective SPOC and will try to share the response. With this, concluding this webinar, I would like to extend a token of thanks to Dr. Anand for letting us know so much about DPDP and the obligations, how those can be fulfilled, and what sort of things we need to keep in mind and how to handle the challenges. And I would like to thank our audience who has participated. Your engagement is what makes Illuminate by Meritto a valuable platform. And we look forward to seeing you in the next webinar for which the information will be provided to you. So thank you so much and have a great day and goodbye, everyone.
Thanks, Surya. Thanks, everybody.